Good morning. I got to figure out which buttons to push and which buttons not to push. So we're going to discuss today a brief overview of the estate tax system and a brief history of the estate tax. What you need to know is that the estate tax basically assesses almost everything that you own when you die. The United States is a great country to live in, but it's an expensive place to die. That's the same thing with the state of Maryland. Anything that you own, with certain exemptions, would be subject to the estate tax, whether you pass assets by way of a will or a trust with beneficiary designations such as a pay on death or a transfer on death designation. You have life insurance policies, retirement accounts, all those things would be subject to the estate tax. Now, in addition to the federal estate tax, here's a surprise. There are 12 states plus the District of Columbia that assesses its own estate tax. So take a look at the list on the screen. Do you see anything that looks common to all of them? Basically, they're either on the left coast or the right coast, except for Illinois and Minnesota. They're high-income states. I wonder why Maryland is highlighted. Let's find out in a second. You're surprised that California is not included as one of the states that assesses its own estate tax. It did until the year 2005. Then it was repealed. But up until then, California was also a state that assessed its own estate tax. Now, there is not only an estate tax that you have to worry about, there's also something called an inheritance tax. So let's talk about the difference between the two. The inheritance tax is applied to assets that pass upon death to certain persons. That is to say, regardless of the size of the estate, if you pass assets upon death to certain people, there'll be an inheritance tax. The estate tax is based upon the entire value of all of the assets in your estate. It's not taxed specifically to individuals, but to all the beneficiaries with a couple of minor exceptions. Generally, throughout the country, and also with the federal estate tax, if you're leaving assets to a surviving spouse or to a charity, the estate tax and most likely the inheritance tax will not be assessed. There are 5 states that also assess an inheritance tax. Surprise. You see what Maryland, how it's highlighted? As Steve said earlier, Maryland is the only state in the country that assesses not only an estate tax of its own, but an inheritance tax of its own. Again, as I think Steve mentioned in his presentation, when clients ask me, how can we avoid the Maryland inheritance tax? You move. But you don't move to Kentucky, Nebraska, New Jersey, or Pennsylvania. Okay? Now, again, we talked about how Maryland is not only subject to the inheritance tax of its own, but the estate tax of its own. I think I'm pressing the wrong buttons here. There you go. So, is the inheritance tax in Maryland assessed upon all beneficiaries? The answer is no. If you leave something to a surviving spouse, or to children, grandchildren, great-grandchildren, to stepchildren, to your parents, to your grandparents, to a charity, to individuals where the inheritance is less than $1,000, to brothers or sisters, and to registered domestic partners, which I'll talk about in a second. Regarding stepchildren, if you are in a second marriage and you leave assets to a stepson or a stepdaughter, no inheritance tax. Let's assume that you are married and you pass away and you leave assets to a stepchild, no inheritance tax. But let's assume now that the husband and wife get divorced. Those stepchildren are no longer stepchildren. So if you go through a divorce and you are you're leaving out your former spouse, which is a likelihood, but you like your former stepchildren, there will be the Maryland inheritance tax. A domestic partner in Maryland, a registered domestic partner, is not subject to the Maryland inheritance tax. What is a domestic partner? Whether it's a same-sex couple or a male or a female couple, that makes no difference, if you sign a declaration of partnership and there are certain requirements we'll talk about in a second, and you register it with the Register of Wills in the county where you reside. And this is very important. You have to pay the $25 filing fee. If you pay the filing fee and you register that partnership agreement with the county in which you reside before you die, then assets that you leave to your domestic partner is not subject to the Maryland inheritance tax. The requirements for this domestic partnership agreement to qualify is that each partner has to be at least 18 years of age. They have to state under oath that they're in a committed, mutually interdependent relationship. They're not married to anybody else, and there is nothing in the law that would have prevented them from marrying if they chose to do so. Let's go back to the federal estate tax. I think all the speakers earlier this morning stated there's not a lot of people that are subject to the federal estate tax. So here on the schedule, you can see that in 2023, there were only 7,100 federal estate tax returns filed, and of them, only 4,000 of those returns resulted in an assessed estate tax. Obviously, we can't tell what the situation would be in 2024 because those returns due this year may not all be computed. The source of this was the Tax Policy Center. So the estate tax is really rarely assessed, at least unless you live in Maryland. Now, what are the current estate tax exemptions? Well, the federal estate tax exemption this year, if you were fortunate enough to die this year, is $13,990,000 per person, $27,980 per couple. As of when the new law was passed earlier this year, those exemptions were raised to $15 million a person and $30 million per couple, and this will be indexed for inflation. The Maryland exemption this year is $5 million per person and $10 million per couple. But here's what you need to know. The scuttlebutt within the Maryland legislature was that they were considering lowering the Maryland estate tax exemption. I heard rumors that they were considering lowering it to as little as $2 million or $1 million per person, $4 million or $2 million per couple. So when Steve mentioned just a few moments ago that life insurance trusts may come back into vogue, that might be a reason why. More than any other state, because of all the taxes we have when people pass away, it's an expensive place to live in, and it's an expensive place to die. Now, not everything that you own, let me rephrase that. When you take a look at your gross estate when you pass away, and what I mean by that is all the assets that might be subject to the estate tax, there are certain deductions that you can take. For example, on the federal return, if the estate had to pay a state estate tax, there's a deduction for that amount. If on the federal return you report a state inheritance tax, there would be a deduction for that. Funeral expenses, burial expenses, other miscellaneous expenses related to the settlement of your estate, such as attorney's fees, thank goodness, accounting fees, costs of getting appraisals of the property, all those types of things are deductions from the federal estate tax return. Now, if you leave assets to a surviving spouse, the likelihood is there'll be no estate tax. Not only if you leave assets directly to a spouse, but in a trust for the benefit of the spouse. We talked earlier about these Q-tip trusts. I feel like this is a repetitive and redundant subject, but we'll talk about it very briefly for a second. So everything that you own when you pass away is subject to the estate tax. In addition, if you've given assets away within 3 years before you died, those assets are brought into your estate for estate tax purposes. If you've given assets to somebody else, but the gift was revocable, that is, you can change your mind later, that is included. That value of the gift is included in your estate tax return. If you own assets jointly with somebody else, for instance, you own property maybe with your brother or sister or somebody else, and you own it jointly with him or her, your proportionate value of those jointly owned assets are included in your estate for federal estate tax purposes. If a trust was created for your benefit, and as we mentioned earlier, you've been given something called a general power of appointment, which allows you in your trust to leave assets upon death to anybody you want, including your creditors, that value of the asset subject to the general power of appointment is included in your estate for estate tax purposes. Life insurance proceeds. If you have a $1 million life insurance policy and you own the policy and it pays upon your death, subject to the federal estate tax. Now, regarding the inheritance tax, and I said everything is subject to the inheritance tax, there is an exception in Maryland. Life insurance proceeds that are paid upon your death, not subject to the Maryland inheritance tax. But retirement accounts, thrift savings plans, 401ks, all those are subject to the Maryland estate tax. The Maryland inheritance tax. And the question is, who is responsible for the payment of those taxes? That is the inheritance tax. And that all comes down to how your trust or how your wills are prepared. Because in those documents, you can either state that if there's an inheritance tax that is due, those who would be inheriting might be personally responsible for the taxes, or those taxes might be paid out of your residual estate. So when it comes to leaving assets, especially with the inheritance tax, you want to make sure that when the documents are being drafted, you consider, do you want the inheritance taxes to come off the top? Or if you want each person who would be otherwise subject to the inheritance tax to be responsible for those taxes. The unlimited marital deduction, again, allows you to leave assets to your surviving spouse, not subject to the estate tax. Here's a kicker, though. If your surviving spouse is not a U.S. citizen, the marital deduction does not apply, because Congress is concerned that if you leave assets to a surviving spouse who's not a citizen, he or she may leave the country. So there are limits. There is an exemption if you leave assets to a non-citizen, but the unlimited marital deduction will not apply. Now, you can leave assets in a trust for the benefit of a surviving spouse, and if certain conditions are met, the assets in that trust for the surviving spouse would not be subject to the estate tax. And here are what those requirements are. The trust must be established solely and exclusively for the use of the surviving spouse. That's the first requirement. The second requirement is that all of the income in that trust must be distributed to the surviving spouse. You can limit how the principal or the initial amount that passes into the marital trust is distributed, but the surviving spouse must be entitled as a matter of right to 100% of the income that is generated by the assets in the trust. And here's something that sounds a little technical, but the surviving spouse must also have the absolute right to demand of the trustee, whoever he or she or it may be, to convert any assets that are in the trust that are not producing income to income-producing property. So those are the basic technical requirements of a trust for the benefit of a surviving spouse. It's called a Q-tip trust. Again, we went over already the technical requirements of the trust, but the reason why these trusts are used is, number one, the principal in the trust can be exempt or protected from the creditors of the surviving spouse. Second, we can control how the principal will be distributed during the lifetime of the surviving spouse. Generally, we want to limit the distributions to health, education, or maintenance. Health and education, pretty straightforward. Either it's a tuition bill because you're taking a class at the community college or not. For health, either it's a doctor bill or not. It's not. The question really is, what does maintenance mean? And what I generally tell clients is, I'm not sure what it means, because there has been very little, if any, law, private letter rulings, code provisions that describe or identify what maintenance means. So I've told clients that as long as you are maintaining the same standard of living while he or she was alive, after he or she passed away, generally the IRS is not going to question that. Who might question it? Well, if there is a marital trust, the likelihood is that there are beneficiaries that will inherit what is left in the marital trust when the surviving spouse dies. And under Maryland law, remainder beneficiaries do have the right to request occasional accountings of the trust to make sure that the assets are being used according to the terms of the trust. So you may not have to answer to the IRS, but you may have to answer, well, possibly to your children, but more likely to stepchildren, children of the deceased spouse who died. That's sometimes where there may be a conflict in how these assets are distributed. And for that reason, if you think there might be a conflict, we may want to consider appointing a neutral third party as the trustee of the marital trust. QTIP stands for Qualified Terminal Interest Property, and that's because even though the trust is set up for the benefit of the surviving spouse, we are limiting to whom the assets might pass upon the death of the surviving spouse. One thing that occasionally clients will ask me to put into a marital trust is a freeze on distributions of principal if the surviving spouse remarries. So there's something for you, but I'd hate to say that attorneys by doing this are encouraging people in the future living in sin, but that's what the law is. Now, if you leave assets to a surviving spouse, that distribution qualifies for the unlimited marital deduction. And generally, automatically, if you leave assets either to a surviving spouse or to one of these QTIP trusts, that generally qualifies again for the marital deduction. But what happens if the marital deduction applies is that the estate tax exemption of the first spouse who died doesn't get used. Example, I leave all of my assets to my wife. Marital deduction applies. What happened to my $15 million federal exemption and my $5 million Maryland exemption? It didn't get used. So the question is, have we lost the ability, if we leave assets to a husband or wife upon death, of taking advantage of those exemptions? And the answer is not necessarily, because previously, a few years ago, Congress and also Maryland as well passed a law which says that if you file a timely estate tax return and you make an election so that the surviving spouse gets to use the unused portion of the deceased spouse's exemption, the surviving spouse gets to use both. So even though, and it sounds counterintuitive, that there may never be an estate tax due because your assets are just below these exemption amounts, it is worthwhile to file the estate tax return for two reasons. Number one, so that the surviving spouse gets the use of both exemptions. And number two, if we leave assets in a trust, one of these QTIP trusts for a surviving spouse, we want to make sure that when the surviving spouse passes away, he or she gets this second step-up in basis. So we've talked about step-up in basis. Let me just explain what that is in case you might not know. If you buy if you buy an asset as an investment, and let's say you pay $100,000 for it, and 10 years later you sell it for $200,000, you have a $100,000 capital gain. If you bought that same investment property for $100,000, and when you die you still own it, but it's worth $200,000, the beneficiaries of your estate, if they want to sell this property, don't have to use your original $100,000 purchase price as the tax basis. That tax basis gets stepped up or increased to the date of death value of $200,000. So now, if you have greatly appreciated assets, when you pass away and you leave something to your husband or your wife or to children, you get this step up in basis. It saves possibly years of capital gain. Now let's assume husband dies first, because if you're a client of mine, you know that in my rules the husbands are always the ones who die first, right? And I learned this the hard way. I'd rather have the husbands angry at me than the wives angry at me. So let's assume now we set up this QTIP trust for the benefit of the surviving spouse. I prepare an estate plan. We have this all set up, and 2 weeks later, husband dies. We set up this marital trust, and the husband was a young guy. Surviving spouse lives another 25 or 30 or 40 years with this marital trust set up. We could possibly eliminate 30 or 40 years of additional capital gain on the difference between what the step-up in basis was when the first spouse died and the value of the assets when the surviving spouse dies. So we can get a second step-up in basis to the date of death of the surviving spouse if we file an estate tax return and make the Q-tip election, the assets in the marital trust are then, for estate tax purposes, considered assets that are owned by the survivor, and then the children will be very happy. Not that the surviving spouse died, but they get this extra step up in basis. We talked about the Portability Act, so let's keep going. What are the estate tax rates now? Well, the current federal estate tax rates are 18% to 40%, depending upon the value of your assets. In Maryland, it's 0.8% to 16%. Also, a graduated estate tax system, which means it's not 18% on everything. The first few $1,000s may be subject to 0.8%. The last $3 million may be subject to 16%. Let's talk about where did we get here? How do we get here with this estate tax? What I'd like to do is talk about very briefly the history of the estate tax. You remember your high school U.S. history? You remember the Stamp Act? The Stamp Act was in 1765, England imposed on the American colonies a very unpopular tax called the Stamp Act. The Stamp Act was a device that was used to pay off the debt of England from fighting the 7 Years' War. Remember the expression, no taxation without representation? That was the original Stamp Act, and it assessed a tax on all written documents, including wills, that were written in the colonies. The tax was repealed in 1766. Well, guess what? The colonists learned all about how great this was. They passed their own Stamp Act in 1797. It was created to fund an undeclared war with France. It was a tax on stamps required for wills, letters of administration, and receipts of legacies. The cost of this tax was based upon the size of the legacy, or the amount that was being inherited. Good news for the colonists, the Stamp Act was not imposed if you were a widow, if you were a child or a grandchild of the person who died. It was repealed in 1802. The estate tax rates for the Stamp Act of 1797, you'll like this, was for bequests of $50 to $100, 25 cents. From $100 to $500, 50 cents. Each additional $500 inheritance was subject to $1. The estate tax exemption was $50. Next, we passed the Revenue Act of 1862 to help fund the Civil War. It was assessed on beneficiaries, not on the entire estate that a person left. Again, it was enacted to fund the Civil War. It was intended to serve as a succession tax. It was imposed, first of all, just on non-real estate assets, and then in 1864, Congress liked it so much, and they needed the money, they added also an inheritance of real estate. The tax rates ranged in the Revenue Act of 1862 from 0.75%, for all of you non-math whizzes, that's less than 1%, to as much as 5%, depending upon the relationship of the person who died to the person who was inheriting. Estate taxes to a surviving spouse, not subject to the Revenue Act of 1862. There was a 0.75% estate tax on inheritance to ancestors, lineal descendants, which means children, grandchildren, or brothers or sisters. A 3% tax was assessed on an inheritance received by an aunt, an uncle, or your cousins. Everybody else, the subject tax was 5%. It was repealed after the Civil War ended. Next time we passed it was to fund the War of 1898, the Spanish-American War. It was taxed only on personal property, which means anything other than real estate. It was a graduated tax. It was assessed at anywhere from 0.75% to 15% of the amount that was being inherited. The first $10,000 were exempt from the estate tax. So notice back in 1898, $10,000 exemption. In Maryland now it's $5 million a person. The feds, $15 million per person. So we have increased the exemptions over time. However, this tax was repealed in 1902. In 1916, we imposed the estate tax again. The Revenue Act of 1916 was really the genesis of what we have today. It was enacted to fund World War I. It was basically the first iteration of the modern estate tax. The estate tax rates were 10%. There was a $50,000 exemption. It was not only enacted to fund World War I, but also to try and prevent the concentration of wealth in certain families that had a lot of else back then. It's never been repealed. Well, wait a minute. It actually was, very briefly. It was in effect in some form or another until 1916. But there was 1 year there was a glitch in the law, and that was in the year 2010. What happened was we passed an estate tax codification change that was good from the year 2000 to 2009. 2010, we couldn't agree on what to do, so there was 1 year, 2010, where if you didn't want to, the estate did not have to file or pay an estate tax. People who died in 2010 whose estates did not pay an estate tax: George Steinbrenner, the owner of the Yankees. Dan, by the way, if you're an Oriole fan, that really just got on you. Dan Duncan, a billionaire who is a pipeline magnate from Houston, Texas. John Klug, a billionaire who is a media mogul. And Paul Millstone, a billionaire in New York City, a real estate magnate. Those estates did not pay an estate tax because they died in this 1 year in 2010. Now, if you died in 2010, well, you really didn't have a choice. It was your personal representative who had the choice as to what to do. The personal representative could choose either to exempt the estate from the imposition of the estate tax, but forfeit the benefit of step-up in basis. Or they could choose to be subject to the estate tax that was going to go into effect in 2011, but retain the step-up in basis. Now, here's the thing. If you owned a lot of highly appreciated assets, even though you would lose the step-up in basis, because those estates were so large, the accountants, the CPAs, the attorneys realized that it was more advantageous to not pay the estate tax, but swallow the capital gains exposure. So that's a brief history with as much minimal amount of legalese as possible that I could come up with. Thank you for coming.